Okay, I know we're still have some people still coming in here, but I'm just gonna get some little housekeeping tasks done with while we wait for the completion of people to join. So good afternoon and thank everyone for joining us today. My name is Jay and I'm the office manager here at Standpoint. And I wanted to begin today by reminding you that this webinar is being recorded. When a link is available, it will be sent out to our legal advocates listserv and also added to our YouTube channel. My role today is going to help facilitate the webinar. If you have questions during the presentation at any time, please type your question either in the Zoom chat box or the Q&A tab. I can pass that along to our presenters if they don't see it. Most of you are probably already familiar about Standpoint already, but for those who are listening to this later on our YouTube page, Standpoint is a statewide organization. We are a team of attorneys and advocates working to assist individuals who have experienced domestic violence, sexual violence, and trafficking when it includes domestic or sexual violence. We also provide assistance to systems professionals who work with survivors. We do this by facilitating trainings and answering calls to our action line. Examples of trainings that we do are our annual new laws training throughout the state of Minnesota, monthly webinars for advocates such as this one, and other trainings by request. Our action line is answered Monday through Friday from 9 a.m. to 4 p.m. And it's through our action line that our attorneys provide legal advice to survivors and our advocates connect callers with resources, safety plan, listen, and help callers identify possible options and next steps. For today's presentation, I will right now share in the chat box the Dropbox link to the PowerPoint handouts and materials that will be referenced in today's presentation. So that is in the chat box right now. So I'm going to go ahead and introduce our presenters today. We have Beth Assell, our staff attorney here at Standpoint. Beth joined the team in October of 2020. Beth graduated from law school at Hamline University and directly after graduation clerked in juvenile court in Hennepin County. Most recently, she worked as a staff attorney at Central Minnesota Legal Services for 6 years. At CMLS, Beth provided direct representation and legal advice in the fields of family law, orders for protection, harassment restraining orders, and criminal expungement. She also partnered with the Domestic Abuse Service Center to represent victims of sexual and domestic violence and strengthen the capacity of advocates working in these fields. Beth previously worked as a full-time volunteer with Lutheran Volunteer Corps and AmeriCorps and brings to Standpoint a lifelong passion for advocacy and helping others. We also have our legal advocate, Madeline Nelson. Maddie joined Standpoint's team in October of 2022. She comes from St. Louis County, where she began her work in the field of domestic violence in 2016. Her primary experience is in providing civil and criminal legal advocacy to victim survivors from within both a shelter and resource center setting. In her prior role, Madeline served on a team within a police department, assisting in the facilitation of a coordinated community response to DV-related crimes. She is affiliated through board and committee service with nonprofits in northern Minnesota, whose missions involve reproductive justice, gender-affirming healthcare, and expanding access to affordable housing. Maddie has a master's in advocacy and political leadership from the University of Minnesota Duluth and received her bachelor's in communications with a minor in women's studies. So with that, I'm going to toss it off to Maddie and Beth.
All right, welcome everyone. Thanks so much for being with us today, and thanks Jay for giving us that great intro. So today we are going to be talking about emergency relief in family court. The goals for this webinar are to understand just what emergency relief is and how it can be requested in a family court action. We're going to explore what types of things family court judges consider an emergency and discuss alternate options to filing something like this. We also have some case examples that we're going to discuss, but we're really hoping that after this, you'll have a higher level of confidence in explaining the different options your client has for protecting their children in family court, and that you may even be able to start to walk them through the process of filing an emergency motion.
Yeah, absolutely. Okay, so these first few slides are gonna, like Maddie said, our first goal kind of go into the background of motion practice and what is an emergency and what's an emergency motion. If at any time I slip into using a word that maybe just someone has a question about, what do I mean? What does that mean? Anytime, feel free to put something in the chat or the Q&A, and we'll try and address those questions along the way. We just want to really make sure this is helpful and making sense. So one thing to start with is what is in family court, what is typical motion practice? So meaning typical, I mean non-emergency, but just someone bringing kind of a standard motion. And a motion is one of those words that you hear used a lot in family court. You might also hear it in the context of other court proceedings, like in order for protection, there can be something called a motion to modify. So to start, what is a motion? And a motion is essentially a formal request for a court to do something. So usually it's to issue an order or decide a contested issue. So motions can be brought at several different times during a case. For example, it can be what we're calling like in the middle of the case or during the pendency of a case. So after it's been filed, but before there's a final resolution, people can bring motions in family court that can include something like a temporary motion for parties to get some kind of relief, get something ordered, temporary parenting time, temporary child support, while that case is still going on, while they're still waiting for that final order. But at the same time, a motion can also be brought after a final order, sometimes called a post-decree motion. So for example, if you have a party with a divorce decree from 2 years ago, and that's all closed out and the case is finalized, they can still go back into that case and reopen it by filing a motion for some kind of relief, for example, a motion to modify custody. And filing a motion is the formal way to ask the court to do something, as opposed to an informal way, such as sometimes people write an email, write a letter. Unless the court has said otherwise, a motion is going to be the preferred way because it's governed by court rules and different processes. So a typical non-emergency motion is going to require certain things. It requires that you obtain a court date in advance. And this may differ depending on the county, but usually that's going to be just calling court administration and asking for that date and then getting the next available, which depends on how busy your court is, could be months out. Typical non-emergency practice, motion practice has a lot of rules regarding notice to the other party. So for example, one area of notice is as soon as you get that court date, the person who is bringing the motion, the person filing, is supposed to, under the rules, give immediate or same day notice of the date they obtained and list out the relief that they're seeking. And there's also notice in the sense that there's really strict timelines about when you have to file that motion and when you have to serve or give notice to the other party. And then they likewise have strict timelines of when to respond. That's strict enough that under the rules, if someone doesn't follow those notice deadlines, that those very specific dates of when the other party has to be given the motion and things like that, the court can dismiss the motion or refuse to hear it. Or if it's a responding party not meeting deadlines, they can even do what's called consider the motion unopposed. So it just ignore their answer. Typical motion practice often also includes that there has to be an attempt at resolution with the other party before filing the motion. Of course, there's some exceptions that apply, but just in general, that is a requirement. So then in contrast, emergency relief is same kind of idea that you're filing a motion and you're trying to formally ask the court to order something to give you what's called relief, but you are essentially asking the court to waive everything that we just went over. You're asking the court to waive you getting a court date in advance and giving that that same day notice of getting the court date. And you're asking them to waive all those normal motion deadlines on the basis that there's an emergency, that there's some kind of really urgent issue that needs to be addressed now. And due process in court is really based upon that notice and that opportunity to respond and to appear. And so the emergency relief that restricts these rights is meant to be really limited. So emergency relief is not supposed to be a common practice. It's supposed to be, it exists for a reason because there are legitimate emergencies, but it's also meant to be pretty limited. an emergency relief, we're definitely going to touch more on this later, but it can be what's called ex parte. So kind of similar to OFPs, when you parties always file their petition what's called ex parte, meaning without advance notice to the other side. They're filing it and then they get back what's called that ex parte order. And only after the fact does the other party get notice. This emergency relief in family court has the potential to be ex parte. So potential to be getting an order signed by the court solely upon the person applying their words and their affidavit. So big question in family court is what defines an emergency? And there is no one specific checklist that courts go off of. They just kind of get some guidance from the court rules. And the guidance is really just kind of these like buzzwords that you have to pick out. So for example, one rule says that it has to appear from specific facts shown. So the person filing has to show that there's a chance of immediate and irreparable injury, loss, or damage that will result to the applicant. Another court rule also talks about how there has to be a finding of immediate danger of physical harm to the minor children of the parties. These emergency motions in family court, there's a potential that they can also address financial relief. There can be some financial emergencies where an application has to be made quickly before an asset disappears, for instance. I think most commonly you're going to see them when it comes to danger to the children, and that's really what we're focusing on, since that would likely be of most interest to the advocates listening to this. But really the key terms that you're thinking of in family court in terms of an emergency is that there's something immediate, something irreparable, and that harm that cannot be undone if you were to wait that kind of normal amount of time to bring a non-emergency motion. And another thing to keep in mind when judges are looking at what's an emergency is the rules direct them that the emergency can't be caused by the lack of due diligence on the part of the moving party. So what does that look like? Like for instance, let's say there's an important deadline next week for school enrollment and parents waited until now to talk about it and realize they don't have an agreement. You might have a really hard time convincing a judge that this is an emergency, even if they're going to miss out on an opportunity to get into that school, or you're going to be late for that deadline, because they might be focused on that lack of due diligence, that there was time to discuss this, the parties knew they had joint legal, and that this should have been discussed in advance. Just one potential example of what that could look like. So some case examples, so potentials for emergency. Cases of kidnapping, where a parent, maybe where there's an active court order, but a parent isn't following it. And there's, along with that, some kind of danger or urgency. There's a real concern that there needs to be an order now to get that child back and that the parent's not going to abide by the order. Mental health concerns that impact the child. If a child's exposed to domestic abuse in the home of the other parent, and that's exposing them to some kind of imminent physical danger, that can be a possibility. Chemical dependency issues that impact the child. They're all potentials. It's all going to be really nuanced and fact dependent, like everything in family court, I think. But one thing to remember is that the court kind of has to be reactive and not proactive. So meaning, one frustrating thing about family court for people is that the court can't just always assume an emergency is going to happen, or they more have to react to something that's already happened. So for example, sometimes you see people saying, I want to file, like a grandparent saying, I want to file this third-party custody case. My grandchild's been living with me for a year, which is such a good thing because I'm really concerned about them with their parents. But I know as soon as they file this, my grandchild's mom is going to come snatch her out of my house because she's going to be mad. So I want to first get emergency custody and then go forward. And unfortunately, that's not really going to work. You can't really file an emergency motion saying, I really think she's going to come take her and she'll be in danger. You kind of have to show more. show that that danger is actually happening, because again, this relief is supposed to be really rare and really limited to emergency situations. So just some facts on procedure on how you actually file these emergency motions. So one thing to note is there has to be an underlying case along with the emergency motion. And so what we mean by that is they have to be filed into an existing family court case. So examples like a divorce, custody between unmarried parents, third-party custody, meaning that you can't just go and file just an emergency motion and open a case with that. Court administration shouldn't accept that and should tell you there has to be some kind of underlying case. So for example, I've seen an unmarried mother who was trying to get back her children from the father. And she didn't want to start a full-blown custody case for a good reason, because she was an unmarried mother and had custody pursuant to statute, but wanted her kids back. So she went and tried to file just an emergency motion. And court administration wouldn't accept that, was told that first there'd have to be an underlying custody action, so she was turned away. So the type of action is obviously going to depend upon the circumstances. So for married parents, it might be a divorce is the underlying action. For unmarried parents, it could be a custody or paternity case, or third-party custody if it's a grandparent or other non-parent who's seeking custody. And so sometimes you're going to be in the situation where you don't have a case yet. Maybe it's a married person comes to you and saying that they have an emergency and they need an emergency order. In that case, they might have to not only file their divorce, so all the underlying paperwork for a divorce, but at the same time or shortly thereafter also file their emergency motion. So it can be difficult for a client to not only get through all that underlying paperwork, because we know that even just kind of starting and opening that family court case can be a lot, but in addition, formulate their emergency request and complete all that paperwork. But you can also file into an existing case. Let's say you started a divorce 2 months ago and an emergency arose. The emergency motion will be filed into that case. Or a custody case that ended 3 years ago, but now there's an emergency, you can reopen the custody case and file into it. And there's certain paperwork that you have to file. Later in this PowerPoint, Maddie's going to run you through some sample paperwork that we got from Hennepin County. Some counties, there are no statewide forms for emergency paperwork. It's a question we get a lot, and the state courts that provide a lot of forms, they've made the decision not to provide emergency forms. So there's no statewide, but some counties do have their own. So for example, Hennepin County has emergency paperwork for litigants in Hennepin County. So we have that example. It's kind of built into our PowerPoint. Maddie will go over that with you. We also created our own forms for advocates to use and help their parties fill out in the event of counties that don't have this paperwork. And what you're going to need is, first, you're going to need your motion for ex parte or emergency relief. You're going to need your supporting affidavit, a proposed order, and then in the cases we talked about where there's not already a family court case open, you're going to need the underlying paperwork. Like with any motion, you're going to need to pay a filing fee. And just know that if the motion is granted, if the relief is granted, a hearing has to be held within 14 days. And relief can be denied with or without a hearing. We have a question that says, if there was no existing case, is there such a thing as a general family court motion for something like a request for an order for law enforcement to return a child to the unmarried mother? So there are general family court motions, like there's general family court paperwork that you can fill out. The main problem is that when you go to file it, kind of the guidance from courts is that you need to file it into one of their existing cases and kind of what they recognize. So like a divorce, a custody, a third-party custody. I've seen people turned away from that. So that's kind of what I would say is you would need to start an existing case then if an emergency motion is going to be appropriate. I've seen, I think, court administration slip up before and open just a general family case and call it in just with the motion, but that I think court administration acknowledged that that wasn't appropriate. So really my understanding and what all these counties that have this paperwork are telling people is that you need to have one of their existing cases. So for example, if it was between unmarried parents, there would have to be kind of your general custody case with all that regular paperwork, like your summons and petition to establish custody. And then on top of it, your emergency motion. There's other options. Like we have that webinar that talks about options for unmarried parents to return their children. We talk about things like a declaratory judgment. There's always that, and that's separate, but to my knowledge, court should not be opening just kind of a general family court case just based on an emergency motion. So I mentioned the paperwork that you have to file. This just explains each one a little bit more and what that means in case people aren't familiar with the motion paperwork. So the actual notice of motion and motion is the form in the packet that lists the relief that the party is seeking, otherwise known as just lists out exactly what they want the court to order. Examples can be that they want temporary custody, they want to suspend parenting time, or order for the other parent to have supervised time. They want a guardian ad litem. They want law enforcement to assist with the pickup or transport of the children. This is what relief is going to be appropriate is really obviously depends on what's happening, but it should really be tailored to the case and what would help fix that emergency. In the sample paperwork that we gave out, we list two things that we think should always be there. Is one, you're asking the court to find that an emergency exists, and so to waive all those normal deadlines and normal non-emergency motion deadlines. We're asking the court to set an accelerated hearing, especially if they deny the relief, to set an accelerated hearing. But then we just give ideas like this, and really the paperwork needs to be tailored and filled out to what's going to be appropriate. And you can see a lot of things, sometimes like ordering like a hair follicle test if one of the concerns is about drug use, or a psychological evaluation if a concern is about mental health concerns. So you can be creative, but also at the same time try and tailor it, try and make it narrowly focused to the emergency so the court knows that the client is really focused on the emergency. One thing I note at the bottom is what's called the caption. So the top of the paperwork where it has the name of the petitioner and the respondent and the court file number has to match the current order. So if you're filing into an existing case, let's say, look at your divorce decree, and from that case, the caption is going to match. If there's no order and you're opening a brand new case, the person filling out is going to be the petitioner. An affidavit is a sworn statement that accompanies every motion. Any type of motion you bring in family court, emergency, non-emergency, whatever it may be, has to be supported by an affidavit. And that is just your client's written testimony about why they think there's an emergency, what they're seeking. And we're going to go into this later again, but if they're making a request that the motion be ex parte, meaning just one-sided at first without any input from the other party, they also have to justify that. Affidavits should be very detailed, just knowing that, especially when you're asking for emergency relief, you're asking for an order before the court holds a hearing, before the court hears any more from you. It's not like a chance in a normal motion hearing where you get to go kind of talk and expound on what you filed. So they should be very detailed. And I think some good advice to pass on to your clients is to the best they can avoid just presenting conclusions. So what we mean by that is it's hard, I think, for a court to maybe justify that there's an emergency and they have to give this extraordinary relief if somebody just writes, the father of my children is very abusive, and just leaves it at that. There's maybe not enough there. So when possible, try and support that with some examples, some illustrations, so the court can really get a sense of why this is an emergency. Like with other affidavits and non-emergency motions, and like with petitions for orders for protection, you can attach exhibits. Definitely done that before, like attach text messages, pictures, You can provide affidavits from other parties. And affidavits don't have to look any certain way. If it's if you see one written by an attorney, they break it up into paragraphs, you know, just paragraph 1, 2, and just kind of make each point in a separate paragraph. There's no rules about how that looks. That's really more just for readability. It can just be a written statement. The big thing is that it just has to be signed under what's called penalty of perjury. And the sample affidavit that we give that you should be able to see in your Dropbox has that language. So that should all be taken care of. Okay, I think we have a question. It says, if a couple files OFPs against one another and both are denied, can a judge then order them into community mediation to figure out custody and parenting time? I mean, it kind of depends. So if they're both through the OFP process, the courts aren't supposed to be mandating or ordering mediation. So it sounds like this might be after the fact, like through a custody case. So courts do commonly order mediation or some kind of alternative dispute resolution through family court actions. It's pretty popular, but there is statute, and it says in the general rules of practice that if a party alleges to be a victim of domestic abuse, the court shouldn't be forcing this mediation. There's also some language somewhere about if a party can't afford it. So it just kind of depends. I think, unfortunately, we do see that happen a lot, that parties are strongly encouraged, if not forced, to try mediation. But if a party is claiming to be a victim of domestic abuse, they should not be forced to do that mediation. Okay, one other piece of paperwork you have to file with an emergency motion is called a proposed order. Just what it sounds like. You are just filing what you want the court to order. So the idea is that it would reflect all of the requests in the motion, and you're asking the court to sign it. And this is unique to emergency motions. A court may, for a non-emergency motion, you do not have to submit a proposed order, but it is a very strict rule of emergency motions to keep in mind. So we have a sample one in our sample paperwork that we gave you. And with these proposed orders, just know that even though you're required to do it, the judge may not sign it. They may completely have their own. They may delete things, they may add things. But it's a requirement we want to make people aware of, because some people just don't know. And the rules around emergency motions are also really strict about, somewhere in the paperwork, exactly what you have to address. So I think the first two are pretty self-explanatory. I mean, of course, you have to explain why emergency relief is requested. So you're explaining why what's the emergency, what makes this special that you wouldn't do the normal motion practice, and why it's an emergency, and the exact relief requested. You have to include, and these other things are a little more unique that maybe people wouldn't know if these weren't, if it wasn't pointed out to them, because again, it's unique to emergency motions. The person petitioning for the relief has to specifically say if they've made a prior attempt to obtain the same or similar relief in the result. So for example, if they filed an emergency motion a year ago and it was denied, they have to say that in their paperwork. If that part applies, if they did make that relief, if they did make that request before and it was denied, they have to name the judicial officer who made that decision. And if the prior request was denied for same or similar relief, you have to be able to explain what are the new facts to support the motion this time around. So essentially, yes, I applied before to this judge. They said no, here's what's changed. If a party doesn't include this in their motion, it can be a basis for a court to not grant it, not consider it. So it's really important to have that. And you'll see that in our sample paperwork, we do have all those things laid out so that parties won't forget. Another thing that's pretty unique to emergency motions is if you want to make it ex parte, meaning you want to make it just based on your written statement, your application, without prior notice to the other party. Two really strict things you have to include. One possibility is some kind of written statement that you've made a good faith effort to contact the other party or their counsel and you can't reach them, so you can't give that notice. But I think most commonly what you're going to see is the second one. And essentially you're asking for good cause why notice to the other party should not be required and why that notice requirement should be waived. That's the one you're going to see most often. And for example, people would say something like they're asking not to give prior notice because they think if the other party got prior notice, that would make them leave with the child because it's something they threatened. They're ready to do it. That's the emergency. That would be enough for them to leave. Or it would lead to that person maybe being abusive to the children or to you or something like that. Those can all be possible reasons to try and justify that lack of notice. But just note that even if the court justifies upfront, yeah, this can be ex parte, after the fact, the other party is going to get served. They're going to get notice of it. And there's going to be a hearing. So they're going to have a chance to respond. It's just important for people to know that the other party is going to get notice of the allegations, and that might include some safety planning. I think the last thing before we go over some sample forms is that this is for potentially with these emergency motions. One thing to keep in mind is you may only get temporary relief, meaning that the court may just order enough to resolve the emergency. So for example, they may order a child back to the parent that they're supposed to be with, but it wouldn't long-term modify custody and parenting time. For some cases, that's going to be enough. All you need is that emergency relief, that temporary relief, and if it resolves the emergency, that's what they need. Other times, clients are going to need both. They're going to need some kind of temporary relief to try and resolve that emergency, but also some kind of permanent relief. For example, modifying custody because there's going to be long-term endangerment. So if you see attorneys draft these emergency motions and they know that they're going to need temporary and permanent, you may see them kind of fit it all into one motion and affidavit. Ask for the court to order everything and address the temporary and the permanent. I think with parties filing on their own, that's going to be a little more difficult, especially with things like a motion to modify custody, for example. There's really specific things in the law that you have to hit on to make it to make sure you're hitting on everything that needs to be addressed. So what, for example, Hennepin County that has sample forms, what they recommend is that litigants who are representing themselves and filing for emergency relief do two things. So they file their emergency motion to get the temporary relief. But if they're looking for long-term change, like a long-term changing parenting time or modifying custody, that on top of that, they also file a permanent motion. They basically access the court's existing paperwork for a motion to modify custody and file at the same time. I think you'll find our paperwork to be the same way. It can be modified. That's kind of what it's there for, to list the relief, but I think parties would be most successful filing an emergency motion and a permanent motion if just temporary relief isn't going to be enough. Okay, we have a couple of questions. Maddie, do you mind if we try and answer those before we move on to the sample forms? Okay, so one question just says, forgot the second part. If one party cannot afford mediation fees, what happens next? That's a good question. I don't know it offhand, but I do remember, I believe there's part of the statute that says a court is not supposed to mandate the mediation if a party can't afford it. I will do my best and try and find that before we end here so I can answer that better. And then someone said, if someone has a custody case in County A, but all involved parties later move to County B and an emergency occurs, can they file the emergency motion in County B? Good question. So I think what you're going to see is you should file, excuse me, into the existing case, even if the parties don't live there anymore, because that's where the case is. That's where the existing court file is. But if it's important to the parties, one thing you can do is ask to change the venue to the court. On the court's website, they specifically have paperwork to change venue. So like change from Ramsey County to Washington County, for example, and that could be on the basis that no parties live in Ramsey County anymore. And the child's in Washington County now, and all the evidence and witnesses that may be relevant are in Washington County, and that can be a reason to move it, but you would have to make that formal request to the existing court file. You shouldn't just open a brand new case based on the fact that no one lives there anymore. Always go back to your old case.
There's also a question in the chat. It says, if a petitioner is granted an OFP, can she add a child to the case later?
I don't know necessarily that I've seen that done. I don't think it's impossible. I think it's possible. But you would essentially, it would probably have to be more than just like a motion to modify. The court would probably have to treat it, since there's a new protected party, like there's a brand new protected person, go through the whole process again of, is there going to be an ex parte? Do you have a basis for that child to be added? Like, are they a direct victim of abuse? I'm guessing the respondent would have to have a chance to have an evidentiary hearing just on the child if they haven't had that after. So it depends. Maybe you might at that point just want to file, kind of depending on the timing and things, file a new OFP for the child. I don't know, Maddie, have you seen that specific situation?
I think that I have, yeah. There was an incident, a qualifying incident that came after.
Yeah.
And so they filed for a modification to have the child added, and it was granted.
And what did the respondent have a chance to like ask for a hearing and have an evidentiary hearing, or how did you see that happen?
I believe so. I think that it actually required a change in custody. So
Okay.
Yep, it required a hearing.
Okay, so it was quite a big qualifying incident after the fact.
Yeah. Yep.
Okay. Yeah, so it sounds like it's possible. Maybe not super common. Judges may be as confused as I am about how to handle that, but I think it's possible. Okay. So then Maddie was gonna show you this, some sample paperwork.
Yeah, so these are the forms they use in Hennepin County. Like Beth said, it's important to remember that these aren't statewide forms provided by the courts for pro se parties. Ramsey and Hennepin, and I think one other, provide them, but most don't. So because of that, the packet we provided you is something you can adapt to use in your county. It looks a lot similar to this. We do recommend, though, that you contact your court admin before using it, just to determine if there's a more appropriate set of forms for your area. And then also really helpful in the packet we sent you, there are instructions for each form. So if you have any questions about filling these out, you can certainly call us, but you can try referring back to that too. Beth did a great job of explaining things. So the first one we're looking at here is the ex parte motion for emergency relief. This is where you'll list the specific relief you're requesting. So it could be confusing if your client is the respondent in an existing family file, because even though they're filing this motion, they should also be listed as the respondent on these forms, so that it matches the existing file. So just keep an eye out for that. On this Hennepin County form, there are boxes you can check to note the relief you're asking for. On the forms we provide, you can just write it in. But as you can see, it's things like immediate temporary sole physical or legal custody, a suspension or supervision of parenting time, an authorization of law enforcement to physically retrieve the children. And I would think that this would be a good thing to request anytime the adverse parent currently has the children, just in case you're dealing with law enforcement that you anticipate is going to tell your client they don't have the ability to physically retrieve them, which we know they often do.
They do. So unless they see it in that order, and sometimes courts will even write like, if necessary, law enforcement must enforce, right? They're just kind of covering their bases in case it becomes an issue.
Exactly. So this form is also where you can request an accelerated hearing, just to discuss the issues if your ex parte motion isn't denied. And Beth is going to talk a little bit more about that shortly here. And then you, of course, have to support your request. So you'll just indicate on this form what documents you're including to do that. Next slide. And this is just the signature page. The next. So here's the affidavit. This is where you're going to provide the facts and evidence to support your request for ex parte relief. So again, why the relief you're requesting cannot wait to go in front of a judge. So you'll want to include everything that's relevant that you want the court to know. So this includes facts about your current order. Specifically, you'll see here, what is the current custody or parenting time split?
Yep.
You'll explain your efforts to have the other party served or the good cause you have to not have them served before relief is granted. And then finally, your reasons for requesting it. Specifically, why the situation presented is an emergency. So you'll want to include why the children are in immediate danger of harm. So similar to when you write a narrative in an OFP, you'll want to be really specific and not generalize it. I think Beth already sort of talked about that, but an example would be, instead of saying something like, my child's father is a drug addict, you could say something like, my child's father struggles with a heroin addiction and appears to have relapsed. When I went to pick up our 4-year-old daughter yesterday, I observed a needle sitting out on the coffee table. That's well within her reach. He was nodding off as I was trying to talk to him, unable to help gather the belongings. You just want to avoid listing your conclusions. So, things like it's only a matter of time before she gets hurt in his care, and instead just be really fact-based. And then there's a space for additional information regarding the reasons for your request. So this would be anything else that supports it. Maybe other attempts you've made to resolve the issue that have been unsuccessful. For example, something like, I've confronted him about his use around the kids. He denied there was a problem. You also need to detail any past attempts you've made to obtain same or similar relief. And you should interpret this pretty broadly. So always opt for full disclosure. If you tried to get the same relief in an OFP and that was denied, don't withhold that information. Like Beth said, judges can get pretty angry if they've felt something was hid from them. And if your client's caught doing that, it could very well have a negative effect on this request.
Yeah, even if it's completely innocent, like they don't remember, or it's just I think, well, that's an OFP, that's different. I have seen like judges, they feel like someone is withholding information that can just really churn how they feel about the case and that party, and they get very suspicious. So yeah, exactly what Maddie said, just opt for really full disclosure when you can. Okay, were there any other forms? No, awesome. Did you have anything else, Maddie?
Nope.
Okay. We had a question. Is there a limit to how many times one can request emergency relief and file motions? So, I mean, in the court rules, it certainly doesn't give like, oh, you can only file 2 times. It doesn't have that. I think really what you're looking for is anytime you file a motion in family court, you are, I guess anywhere, any type of court, you are saying that you have a good faith basis for that request and you're not doing it to delay or harass or anything like that. And so there's going to be a limit to how often you have a good faith basis. You have to disclose each attempt you've made and the outcome and the new facts. And so if you don't have new facts, there's no reason essentially to keep trying again because it's not going to be different. So I mean, that in effect limits the amount you can bring a motion. And this is unfortunately beyond the scope of this presentation, but occasionally, very occasionally in family court, you'll see something called a frivolous litigant, where someone is repeatedly filing harassing motions without good faith and without a basis. And there can be consequences for that down the line. I haven't seen it often because courts do want people to have access to the court system and to asking for relief, but generally emergency motions, again, they're going to be so limited. Courts are really strict about what they think is an emergency, so there should not be, clients likely should not be filing repeated ones. I'll say that in 6 years of working at Legal Aid, where there's a lot of urgent situations, a lot of people in highly abusive situations, I only filed 2 emergency motions total. Okay. So we have a question, how to get a child returned with a non-adjudicated dad. There's no case to file into and there's an OFP for her. Law enforcement is saying it's a civil matter. Yeah, super frustrating. That happens all the time. So a couple options. One, we have a whole other webinar about forget exactly what it's called. It's like Give Me Back My Kids, I
Give Me
think
Back
it's
My
called.
Kids,
So
yep.
yeah, so it's on our YouTube page, and it's meant to try and address that problem as much as we can because it's a super common statewide problem. We give some ideas about best ways to kind of advocate for your client and reach out to law enforcement and press them. But then long term, we also included a packet of forms that we at Standpoint came up with SMERLs, with Megan Mays, one of the supervising attorney from SMERLs down in Mankato. Actually, her forms first. She's done a lot of amazing work with them. But it's this whole process called a declaratory judgment that's meant to be exactly for this. I mean, other options, sometimes with an OFP, a court will order the immediate return of a child, even if that child's not a protected party. I have seen that before, more specifically in Hennepin. I don't know if that's statewide, that courts are open to it. Another option is for that mom to open, thank you, Jay, for that mom to open a custody case and file an emergency motion in there. It's a potential option. It's kind of a shame because you shouldn't have to ask for custody when you have it, but it's an option that's out there. You just, maybe an emergency motion isn't for her, but more that declaratory judgment. And the forms for that are on our website too. We have a question. What if there's an OFP in place and respondents filing the same motion? Could that be considered a violation of an OFP? So to my knowledge, somebody filing into a court case, filing a motion and asking the court to do something is not a violation of the OFP. It may be, litigation abuse. It may be seriously annoying and abusive, but I don't think a law enforcement or prosecution would consider that a violation of the OFP because they're pursuing something in court. Okay. I think we answered the questions. I think, okay, for now. But if I'm missing something, let me know. Let's see here. Okay, so in the Dropbox, you'll see that we also have what's called a request for an accelerated hearing. And this, to me, gets a little confusing, but here's where it came from, is that you'll see on the emergency motion forms that we included, it's kind of a joint request. So we're saying, we had it written as in, give me emergency relief, here's my emergency, but also if you're going to deny my emergency relief, please set an accelerated hearing so we can discuss these requests. And you will see judges do that sometimes, say, I don't see an emergency, I'm not going to grant this, but we can hear this on an expedited fashion. So instead of coming back in months, you can come back next week. What we got this idea from Hennepin County, that in addition to the sample forms for emergency relief that they have, they also have just a standalone request for an accelerated hearing. I'm not sure if other counties have it. If you do, please let me know. I'd be really excited to know about that. But essentially, it's somewhere, the idea is that it's somewhere in between filing a typical family court motion with all the deadlines and timelines we discussed and an emergency motion. And the idea is you're saying maybe this is an emergency, but there's some urgency here, right? So not emergency, but it's an urgent issue. And I'd like to get into court sooner than what court admin is telling me to discuss the urgency. So my understanding of the way they handle it in Hennepin County, the one place I'm aware of that actually has the forms and they're actively using them, is you would have your motion, whatever motion you're filing, like a motion for parenting time assistance all ready to go. And then you would file your motion requesting the accelerated hearing along with the proposed order. And we have samples of both in the Dropbox. And the court could grant it and say, yep, here's your date, it's accelerated, it's granted, and then you get that other party served with the motion as quickly as possible. Or they could deny it and then you would just proceed with your normal motion. But if it's granted, the court would give you a date and instructions on what to do next. I don't know, again, if other counties have this or other counties accept it. So what we kind of recommend in the instructions is that you contact your court admin ahead of time just to learn, is there a process that we have for this here? Would a court accept something like this? But if they do, that's a sample form that you could use. So some possible outcomes when you file an emergency motion. So one is it's possible that the court could deny the relief entirely. And then kind of what happens branches out from there. So for example, if a petitioner started a new case at the same time, so let's say they started a divorce case and then filed an emergency motion. If the court denies that emergency motion, the divorce is still going to proceed unless the petitioner dismisses it. Let's say you filed an emergency motion into a case with an existing order, so a custody order from like 2 years ago. That order from 2 years ago is going to continue in existence. It's still going to be the controlling order, and the party who got the emergency motion denied would have to continue with a permanent motion. For example, a motion to modify custody, they wanted a change in the order. Like we just talked about, the court may deny the relief, may deny saying it's an emergency or giving the parties what they want, but they could set an accelerated hearing. In that case, the order that you get back from the judge should include a hearing date and time and instructions on serving the other party. So they should say in that order, for example, that it's the person applying for the relief, it's their job to get the other party personally served as soon as possible. And the idea behind that is to get them a notice as soon as possible so they can participate in that hearing that's coming up quick. Or the court can grant the relief. Of course, they can sign the proposed order or do their own. In that case, they're also going to set a hearing and give instructions on service. And after that hearing, the court may issue a new order based on the information that they received at the hearing. So some common mistakes and misconceptions that we've seen with people filing these is they can forget a proposed order. Again, that's really kind of unique to these emergency motions. So it's really easy to forget and not know that that's required. So that's why we have a sample one in our Dropbox. I think it's really common to assume that notice isn't going to be required. And just remembering that if you're asking to not give advance notice, that really has to be justified. Either that there's good cause or that you just can't give that notice because you can't find them. Not realizing that a hearing will be set, I think that's where the safety planning comes in, of just not realizing that the other person's going to they're going to get a copy. They're going to have a chance to respond. There could be safety concerns, even if it's initially ex parte. And then just a common, I think, mistake is just realizing that not everything is an emergency, even if it's very urgent to the client. And I think that's where advocacy really comes in, is just helping clients talk through that and accept it, and just doing their best to kind of assess their options going forward, and knowing that, again, judges have to be really reactive and not proactive, and things that are very urgent to as a parent, very understandably, may not legally be an emergency. Okay.
All right, so here we have the OFP statute. I'm guessing everyone is very familiar with it, but we wanted to include it just to contrast with the reasons one might request emergency relief instead. So of course, to get an OFP on behalf of your kids, it's a pretty high bar. You have to show physical or sexual abuse, the infliction of fear of imminent physical harm, threats of physical harm made directly to them, etc. So they're not appropriate for a whole range of what we'd consider abusive or endangering behavior.
Yeah.
You know, how many times have we had to tell clients that drug use, neglect, abandonment, drunk driving, abuse in front of the kids, it's just not appropriate. It's not enough to get them an OFP. And I think that, and Beth, can you click next slide there, I think?
Yeah, absolutely.
Thanks. I think helping people understand the limitations of the OFP statute is one of the more challenging aspects of this work. So we're hoping that this training is going to give you a little more confidence in helping your clients assess whether or not they have other options for protecting their kids. Next.
Okay, so just a little bit of comparing and contrasting when you are deciding, is this better for an emergency motion or is this better for an order for protection? So again, like Maddie went over before, OFPs really are or should be limited to situations where domestic abuse has occurred. And that, again, is domestic abuse, how our statute defines it under 518B.01. And again, I think it's really common and tempting for someone in a scary situation, like where there's drug use and neglect, to want to file an order for protection, because in their head, they hear protection. Oh, I want to protect my kids. So of course they want to. But if there really is, if you really sit down with that party and you learn there's really not, there's a lot of concerning behavior here, but it's not domestic abuse. My recommendation is not to use the order for protection because of the risk it will be denied. I think you see some slip through or maybe some close cases where a judge does go for it, but you're always gonna face that risk. Family court proceedings can be a little broader as long as you can show that immediate risk of harm to the child. So things like, drunk driving with the child or drug use, that can be addressed in an emergency motion in family court. In both types of proceeding, you can obtain temporary custody. In the setting of an order for protection, the standard is a little different. The standard has to be when the court's considering temporary custody and temporary parenting time, they have to consider what's safest for the victim and for the child. And as you know, for a child to actually be a protected party, they have to be a direct victim of abuse. And so that's where the distinction kind of comes in of like some judges, witnessing abuse does not make a child a direct victim of abuse. Unless you can show something like they're put in imminent fear of physical harm, but that can be hard to show. And that's maybe where you want to consider if an emergency motion or some kind of motion in family court would be more appropriate. One difference is that, of course, we all know from having worked with a lot of clients with OFPs, is that OFPs have standardized statewide forms, a really set process, and they may be easier for pro se parties to complete on their own just because it is so standardized and those forms are available. Obviously, advocates are there to help draft. There's no filing fee. There's assistance with getting it to the sheriff and the sheriff serving. It's just as much as it can be more of a streamlined process. So emergency motions might be a little more daunting because it could be more paperwork. There are no standardized forms. But for some people, it's going to be their best option. Only with that order for protection can you enforce violations through law enforcement and criminal sanctions, and have those like no contact provisions that we all know from an order for protection. In family court, if someone were to violate an order, it would be an action for contempt maybe, which is a whole other court process with more paperwork and more time. So that's one difference between the those two types of proceedings as well.
Okay, so one other quick thing we wanted to make you aware of, if you're not already, is the existence of an order for protection statute within the child protection statutes. And this is what allows for the agency itself to file. I think many of us have worked with clients who are being investigated by CPS because the other parent is abusive. And in my experience, it's not super uncommon to have social workers tell the client that they have to go get an OFP, not understanding that it might not be safe for them to do that, or they don't actually qualify under the normal OFP statute. So like we said, there's a lot of abusive behavior that just doesn't meet the statutory definition for an OFP, but it might be considered a child protection matter. So this statute expands on the definition of domestic child abuse, which qualifies for this type of order. And the relief under this statute is more limited, but one important thing it can do is it can exclude the abusive party from the child's home. So if social workers are pushing your clients to get OFPs and you don't think that they qualify, or you're worried that your judge is going to see it as a ploy regarding custody, this is a really good opportunity to educate CPS, ask them to file an OFP under their statute instead. So having this handy and being able to tell your clients about it or remind a social worker about it could be really helpful.
So in sum, I think it's best as we can sum up a confusing issue. This particular question, when should you file an emergency motion and when should you file an order for protection? So again, with the order for protection, there really has to be that narrow scope on whether or not domestic abuse, again, how it's defined by the statute, has occurred. All other things that are allowed by an order for protection, like temporary custody, temporary child support, temporary parenting time, can only come after that domestic abuse has been established. And again, we know it's really common for child protection, even law enforcement, to just give everyone the solution of like, oh, go get an order for protection. And it can be really frustrating because that can be bad advice. So I think you really have to sit down and determine with your client if they fit within the confines of 518B.01. Think of evidentiary issues you might have, like, can you show that that child was put in imminent fear of physical harm, or is that going to be difficult to show? I think one complicating thing is that, we gave some options, obviously, maybe pursuing something in family court or that protective order that Maddie talked about. But there are some cases where if CPS is telling your client to do something and they're not really responsive to either of those other options, your client may still feel like they need to do that. And I think they have to do what they have to do when CPS is telling them, but just legally, we're letting you know that often when there's no domestic abuse under the statute, there's just not going to be a basis and it may be denied. If you have both, like if you have domestic abuse plus other concerning behavior, like plus drunk driving with the child or drug use, severe mental health issues that are impacting the child, don't feel like you can't bring those up in an order for protection. Those factors can be really important in terms of temporary parenting time and temporary custody and getting those provisions in place in the context of an order for protection. Just know that the domestic abuse has to be primary. And also just know that if you have an existing family court case, some judicial officers seem to be of the opinion that anything to do with the kids should be brought in the family court case, even if you have a basis for an order for protection. So I think it's just a good opportunity for you to know what your counties and what your judges are doing. There's also just kind of strategy questions that come along with which one you should file. So for example, we've talked about unmarried mothers, how they have sole custody under Minnesota law, but they may run into issues where they need some kind of protection for their child. If you're considering between these two options and they have a basis for either, you may want to consider in that case an order for protection. Because again, when an unmarried mother files for custody, they're opening up a whole can of worms that they probably shouldn't have to because they have custody under the statute. And an order for protection may give them the relief they're seeking without kind of opening up that family court case. Let's say you have an example of a dad, an unmarried father who hasn't established custody or parenting time yet, but he has an emergency with his kids and he needs to get them protected. He could consider an order for protection, but long-term, if he wants custody and parenting time of his kids, he may want to file an emergency motion at the same time he opens a custody case and kind of address it all there. You have to think, is the order for protection against a family or household member? If not, an order for protection isn't going to be appropriate because that is part of the statute too. And just remember, for these emergency motions, you really have to have firm examples of potential of irreparable harm to that child if the court doesn't act. So really firm examples of a party who's going to abscond with the child, or there's serious ongoing safety concerns for the child, like meth in the house, violence in the house in front of the kids that needs to be addressed immediately. And there's no other way to get them out. Okay. Do you have any other examples there, Maddie, or anything else you think we should touch on before we move on to our hypotheticals?
I don't think so. Nope, let's do it.
Okay, other than at standpoint, we can always talk to you about the different options here and which one is better. Okay. So we have some hypotheticals that we just kind of want to go through. I think the idea, right, Maddie, is that, okay, so our webinar goes until 3:30, so we definitely have some time. We were just gonna kind of read these hypotheticals out loud, and then if people are up to it, chat in maybe what you think would be appropriate here. Give that a little bit of time. If we don't hear from anyone, or even if we do, I suppose, we'll just give a little bit of time and then we can say kind of what we were thinking would be appropriate here. So I can start by reading the first one. So the first scenario is, let's say you have Lisa contact you, and Lisa is a mother of Carly, and Carly has a 1-year-old daughter, Mia. So Lisa contacts you as an advocate and alleges that Carly, so again, Carly's Lisa's daughter, left Mia unattended in a grocery store. She also told you that she heard the child screaming on another occasion while she was in Carly's house. And in that situation, Lisa opened the bathroom door to find the mother oblivious to the fact. So she found Carly oblivious to the fact that she had hurt Mia while cleaning her. During another occasion, Mia had been left alone in the home, and Leah says it was apparent that the child's diaper had not been changed in some time. Lisa, so the person contacting you, believes that Carly is using alcohol or drugs while she's breastfeeding, but tells you that Carly denies this. Lisa is very concerned that Mia is in danger with her mother and wants your help deciding what to do. So obviously some limited facts there, right? But just based on that, we're curious what people listening think would be appropriate in a situation, or what kind of questions you have, or what advice you would give to Lisa. So if anyone wants to chat in, we'd be happy to hear from you. I'm just looking for my notes on what actually happened in this case. Well, okay, so we got one comment. I probably wouldn't suggest an OFP in this situation. Okay. All CPS. Yeah, I think that's good advice there too, for sure. So I can tell you that this case, this fact pattern that we have here is actually based on an actual Court of Appeals case where a grandmother in this situation did decide to file an order for protection, and it was appealed and then overturned. And the court found that there were definitely concerns here. There was inappropriate hygiene, there was inadequate medical care, there was leaving the child unattended, there was active chemical dependency while caring for the child. But even if all those things were true and there was that overall neglect, hey Nikki, I believe that what the Court of Appeal said is that there may have been neglect, but that does not constitute domestic abuse. And they really said, the appellate court said that the essentially the closest that came was the washing under the hot water. That's what caused the yelling in the bathroom. They really said that that was essentially the closest, but that it wasn't domestic abuse. So I think good instincts there about what to do, that an OFP would not be appropriate in that situation.
And Beth, would you agree that depending on some of the other facts around this might be a good case for an emergency motion with like a third party custody filing?
I do think it could be potentially an emergency motion. Again, those are all going to be so fact dependent. But in this case, because it's a grandmother, it would be a third party custody action. And then Lisa would have to allege in her emergency motion why there's an immediate risk of irreparable harm. And so, Nikki, what the trial court did in this case is they did grant the ex parte and then did also grant the OFP for 1 year. And that was then overturned by the Court of Appeals, finding that there was just insufficient evidence to support it. And again, because really what you have here is neglect and not domestic abuse.
Okay, I can read this one. So Steve and Sally are unmarried parents with a 2-year-old son, Kai. Steve has already filed a petition to establish custody and parenting time, and the parties have reached an agreement after mediation. Even after reaching the agreement and presenting it to the judge, Sally is no longer allowing Steve to have parenting time and is sending him text messages that are causing him great concern for her mental health. She is also intermittently blocking her phone number and has moved out of her mother's house where she's lived her whole life. Steve believes Sally is living in a shelter, but the shelter staff is unable to confirm to Steve or law enforcement if Sally and Kai are there. Steve is afraid that Sally may leave the state with Kai, as she's done she's done this in the past. So what should Steve do?
Yeah, does anyone have any ideas on what you think Steve should do? Or what Steve would have a basis for? File emergency order. Like that quick answer. Thank you. Seeing what time it is. Yeah, so I can just, well, people are considering it. I can say that this is loosely based on a case I was aware of. And in this case, it was not an order for protection. You're right about that, because there's really, again, you see concerning behavior here. But it was not a case where anything was domestic abuse. And so it was because Steve did have that family court case already open. He and his attorney just filed an emergency motion into that case. And the endangerment they were alleging is serious concerns about Sally's mental health. The text messages were really just angry and incoherent, repetitive. At some point saying things like really clearly, like, I'm not doing well. All while a really young child was in her care. She moved out of her mom's house and couldn't be found. And in the past, she had left the state without Steve's knowledge. In that case, both Steve and attorney had reached out to Sally to try and talk to her, ask her to follow the court order to return Kai, and got really angry, unhappy responses, and then cut off communication. So in that case, it was not only an emergency order, but it was also justified to make it ex parte because of the fact that legitimate fear that Sally would further kind of hide herself if she knew in advance that this was coming. And because of this case, because the shelter was unable to help Steve or law enforcement get Kai, the specific relief requested was to have law enforcement enforce, and that the shelter, that they had the right to go into the shelter to get the child, and that was granted. Okay, so you are contacted by Greta. She tells you that she needs to help her grandchildren. Her daughter Gina is living with a man named Greg. Greg is not the father of her grandchildren. Gina and Greg have been behaving erratically and dropping the children off at Greta's home at all hours of the day and night. They sometimes disappear for days or weeks at a time. Greta is worried that Gina and Greg may be using some kind of drug, but she's not sure what. While staying with Greta, one of her grandchildren told her that Greg pushed him into a wall. He also told her that Greg threatened that if he told Greta about it, he would never see Greta again. Shortly after her grandson told her this, Greta got a text from Gina that she would be picking the children up the next day. Gina has not seen the children for 3 weeks. What should Greta do? Okay.
Someone could go with me.
Maddie, what are your thoughts on this one?
Well, I think that there might be enough there for an OFP against Greg, because there is an allegation of him pushing the child into the wall, and he is a household member. I think otherwise we're looking at maybe an emergency motion.
Her mom?
Yeah, probably, you know, it would have to go alongside again with a third-party custody.
Yeah. Yeah, I mean, I think I would agree with that. If it sounds like the most important person in this scenario to get relief against as a respondent would be Greta, since she's mom and she's the one who has rights to the kids. Just based on these facts, I don't see that Greta herself is committing domestic abuse. I see that Greta is being really erratic and dropping off the kids and maybe using drugs while she's caring for them, and maybe allowing or kind of standing by while Greg is abusing the kids. But I don't see that she's directly causing the abuse. And that should be, I'm saying should because family court's a weird place and some things can change, but our judges handle things differently. But that should likely not be enough for an OFP against Gina. Sorry if I was saying the wrong name. But I think it could be a basis for a third-party custody and even for an emergency motion. And in this case, the emergency being that Gina is telling you she's coming the next day, and there's serious concerns about her ability to protect and take care of these kids. I've seen similar cases with grandparents where they have serious concerns about the parents' ability to care for the kids, and they file for third-party custody based on those concerns. And I know a common question they have, and we said this at the beginning, is they're going to say, I know that my daughter is going to come get these kids and file for third-party custody. And again, to make it that emergency, you kind of have to wait till you have better proof that that's going to happen. And in this case, Gina's kind of giving that proof. I'm coming tomorrow. Nikki points out that there's a possibility that a judge would only grant an OFP for the one grandchild that disclosed being pushed and not the other grandkids. Yeah, that's absolutely true. So it may be that the grandson who got pushed is the only one who is the direct victim of abuse, which could make an OFP tricky. Mm-hmm. And you may find you don't even need relief against Greg, really, because if things are kind of controlled between Greta and Gina by family court, their contact with Greg is going to be limited anyway, but I think it's a potential. We also got a comment to call the police to document the abuse. And yeah, absolutely. I think that's appropriate. We have a question. How quickly has the court turned around with decisions on emergency family orders in your experiences? Good question. Yeah, there's nothing in the statute that says how quickly they have to act. I've seen, I think in the cases I'm aware of, it's, I've gotten a response or seen a response within a couple days. It's not always that quick, but I have seen it within a couple of days. The worst I've seen is just the court kind of not acknowledging it at all and just later setting a hearing. That shouldn't be the case, and you can follow up with court admin if that happens, but if the court's paying attention to it and knows that it's an emergency motion and has been properly filed, all those elements are met, they should be addressing it quickly. Okay, last hypothetical that we have.
Okay, I'll take this one. Tamara and Adam have a 3-year-old daughter together. They've never been married and separated 1 year ago due to Adam's verbal and emotional abuse. Adam recently was awarded parenting time 1 day a week during a time the parties agree upon. Adam has only rarely provided solo care for their daughter and never overnight. Tamara contacts you on Monday because Adam refused to return their daughter after an agreed upon visit on Saturday. He's telling Tamara he's taking her to his mother's in another town and will return her on Wednesday instead. Tamara called the police for assistance, but they've told her there's nothing they can do. Yep. She's concerned because Adam has never demonstrated the ability to care for her for more than a few hours and has already lied about when he would return her. What should Tamara do?
This is a tough one. It's also a really common scenario, I feel like. So unfortunately it's common. And it sounds like in this case, yeah, so he was recently awarded parenting time, so there is an existing court order, right? But it's just sounds like Adam is saying he's not going to follow it.
Right.
Okay. Do you have any initial thoughts, Maddie, or do you want me to start?
Yeah, I mean, I think that, like you said, this is a really difficult one that we hear all the time. And, you know, I guess I don't know if you think there would be a case for an emergency order here, but it's seeming more likely to me that she needs to go back in and get more specific language so she has an enforceable order with law enforcement.
I would agree with that. I think with the facts we have in this hypothetical, calling it an emergency order might be a stretch because Tamara is definitely saying Adam can't really care for her for more than a few hours, but I don't know if that would be specific enough for a court to grant emergency relief unless something, I guess, more happened. But there is a case where maybe she could, again, Tamara could consider maybe filing for contempt and getting relief that way. Or like you said, Maddie, making their order more specific about law enforcement must enforce, asking for that language to be put in and saying to the court that she needs that relief for the future. Or looking at the order and building in consequences for what happens if a party doesn't return the child on time. Those are all possibilities. If this is a county that accepts just a standalone accelerated hearing request, that could be a possibility if someone is not getting their very young child back and they're not certain they can convince the court it's an emergency, but it's very urgent. That might be a possibility here too. Okay, so just a couple more slides. So one thing that we kind of already went over is that emergency motions may not always be appropriate to resolve issues of child withholding and deprivation of parental rights. So kind of went over that in detail a little bit before, but we do have a whole other webinar and some paperwork on a cause of action called a declaratory judgment that could be used for an unmarried mother to seek the return of her child in the absence of any other court order. So something to consider strategically if that's better for your client to file. We kind of touched on this already too, but there's some risk of filing an emergency motion. There's could damage your credibility with the judge if you repeatedly file motions that the court's not considering an emergency. Because again, if one motion is denied, you need to disclose that denial for all future emergency motions. And again, because there is going to be notice and an opportunity to respond for the other party, you have to consider retaliation from an abuser on the safe parent or the child if the motion's denied. Oh, Maddie, you're muted.
Thank you.
Yeah.
All right. So lastly here, we just wanted to, we just wanted to remind you of some opportunities for advocacy. So obviously one of the main things we can be doing is educating clients on what their options are. You know, often all that they've heard is what their abusers have told them. So they might have a really skewed idea of what their rights are or what kind of relief they can get. So it's really important to recognize, though, the potential significance of filing an emergency motion. You know, Beth just talked about some of those risks. So before your client does something like this, we really strongly encourage them to seek competent legal advice. And that's something you can be helping them do as well. We all know that pre-consultations can be somewhat hard to come by. So one way to help our clients maximize their time with an attorney when they do get them on the phone is to help them draft those specific questions they need answered, or maybe even, you know, come up with a list of bullet points we know are going to be most relevant to that conversation. We can be assisting in the collection of evidence and other required information. So, you know, helping them identify how to request it, even just providing a printer, assisting in the organization or storing of it. We can provide the court forms they need, especially in this case where your county might not do it. And then we can assist in drafting and proofing them. So helping them with specific statements that provide important details about why relief should be granted. And then lastly, you know, as always, emotional support and encouragement. So when you share children with an abuser, there are likely to be many undesirable things that are simply out of your control.
Yep.
So helping your client recognize what those things are, of course, validating their pain and fear about it, encouraging them to seek therapy, helping them connect with those therapeutic resources. I know I'm preaching to the choir here, but you know, these are all things that have the potential to make a big difference in your client's ability to navigate and be successful in something like this. So, you know, as we all know, advocacy is incredibly multifaceted and difficult work. So we just want to remind you that Standpoint is always here to support you in any way we can. So do call us. So with that, I think we wrap up. Looks like we have just a few minutes here for questions.
Yeah, we got one question in the chat. It says, going back to the Greta Gina situation, isn't it true Greta would not be able to petition for an OFP, OBO her grandchildren because she is not their legal guardian, just looking for confirmation? Yeah, good question. So, I mean, to me, this is one of the most confusing parts of the statute, but there is some language about a family or household member applying on behalf of a family or household member. And you'll see on the OFP petition, there's a spot where you say, who am I applying for? And it says myself, my minor child, someone I'm a guardian for. And it also says a minor child who is not my own. So I think in that case, if Greta is a family or household member of those grandchildren, it sounds like they've been living with her. She's a grandmother, she could apply. One roadblock that she might run into is if she tries to use that OFP setting as a way to get temporary custody. I think she could run into a roadblock there because the exact language of the statute is, oh gosh, I said exact, but now I don't know exact. But essentially, thanks, Nikki. Essentially what the statute says about custody is that the court can only decide temporary custody of the children of the parties. And they're not grandma's children. So she may have a hard time getting temporary custody. She could potentially get relief against Greg. I hope that distinction makes sense. It can, to me, again, it's one of the most confusing parts of the statute. And I know, before I forget, somebody asked before about what happens if somebody can't afford mediation. So I will answer that now. The general rules of practice, there's 114.101C. Have it there. Oops, I don't think I sent that to everyone. One sec. Essentially, that rules of general practice is just one of the many court rules you can look at to see how all these things are governed. What that says is says that this specifically applies to family court, and it basically says if a party qualifies for a fee waiver, so IFP status, that fee waiver in family court, or if the court determines on other grounds that the party is unable to pay for what they say ADR, so alternative dispute resolution services, and free or low cost ADR services are not available, the court shall not require that party to participate. I don't know if people really bring this up a lot or courts are aware of it, because I've definitely seen parties forced into mediations they can't afford, but it's something I know that was a concern to someone, that mediation can really come up in family court especially. So just wanted to answer that question, that someone genuinely can't afford it, that is something they could try to argue. There you go, that's where I saw that. Okay, yes, you're welcome. Oh, yes, I did mean to go there. So here's how you can contact me. You can contact Maddie if you had any questions for us after the fact. Again, really, I hope you had the chance to look in that Dropbox. It has all the sample forms that we drafted. It has some instructions. It has like the fee waiver and affidavit of personal service that a party's going to need if they do file one of these. So it should all be there. I'm sure questions will come up later as you actually start to use them. So feel free to reach out. Thank you, Jay.
Yeah, I just dropped the Dropbox link in the chat again as well, if people need that as a reminder. And I will also email that out to our advocates listserv when I send the recording of this webinar. And then if there are no other questions for today, thank you, Maddie and Beth, for presenting today. If there are no other questions, looks like some thank you, well done's coming in. Thank you so much. Thanks everyone for joining us this afternoon. And now I'm going to end the webinar.
Okay, thank you, everyone.
Hey, everyone, thank you.
Bye.